Thanks everybody for coming. Welcome. My name is Matt Daniels. I am the founder of Goodwall and the director of our Center for Human Rights and International Affairs here at IWP. For those of you who are new to IWP, IWP is an independent graduate school of national security and international affairs. We're grateful to IWP for hosting this event today. John and his team have been great. I hope we can have a substantive discussion. Is the audio good on that? Okay. We're joined here today by David Iglesias. David is a public servant with a long history in public life. He now also is teaching. He is the director of the Dennis Hastert Center at Wheaton College in Wheaton, Illinois. The Hastert Center is a free market limited government think tank established by, you guessed it, former House Speaker Denny Hastert. David runs the institution. He also teaches at Wheaton, both politics and law. A little bit of background on David. After graduating from Wheaton in 1980, he attended University of New Mexico School of Law. After that, he joined the Navy as a judge advocate. Early in his legal career, he prosecuted a case at Guantanamo Bay. The case involved an assault on a Marine by some of his peers. Little did he know at the time that the case would become a major motion picture featuring Tom Cruise, Demi Moore, and Jack Nicholson. Some of you may have seen it. You can ask him about that if you want. I'm sure the movie is entirely, completely accurate, that no liberties were taken by anyone involved in the production of the film, in keeping with the media's commitment to accuracy. After leaving active duty, he joined the Navy Reserves, returned to New Mexico, where he held various legal positions, including assistant AG, assistant city attorney for Albuquerque, and then eventually U.S. attorney for New Mexico, where he served a 6-year term. He's a member of the Navy Reserves, and through all of this, continued to serve his country in that capacity. He became a senior prosecutor for the military commission at Guantanamo Bay. Finally retired from the Navy in 2014 after 30 years of military service. David is a true public servant. He has a lot to offer in terms of his understanding of today's topic, and I would ask you to please welcome him to IWP.
Thank you very much. Is this working okay? All right. I just found out minutes ago that this is a former KGB building. So I'm trying to wrap my head around that. I'm not sure what to think of this. I tell you, it's a beautiful venue. I want to thank Dr. Daniels here for inviting me, and thank you, David Rausch, for sweating those details that have to be sweat. So I actually found the place the first time, found parking. I don't see any tow trucks out there, so I think we're good to go. So this will probably be a little bit on the short side, which is intentional because I really would like to hear questions from you all. I imagine some of you have substantially more experience in national security issues, on human rights issues, than I do. But I would like to hear from you all. Probably the best advice I ever received about public speaking was something I learned at the Naval Justice School in the mid-1980s, and that was keep it short and then cut it in half. So I will try to do that. I would like to take a few minutes to talk about a very special Marine Corps officer who, in his way, was a herald of good news. I will also talk about human rights, the folly of abusive interrogation techniques, and the way ahead. I've had the privilege of serving with many fine Marines over the years. Most recently, the Office of Military Commissions, where my prosecution team of all branches was led by a Marine who was able to secure a guilty plea, only one of 6 completed war crimes cases since the commissions were reestablished in 2001. I also know that some Marines are fond of saying this. I'm sure you've heard this. Marines are good at making noise and breaking things.
Not only Marines.
Other branches as well. But this will not focus on that skill set. This will be a story about an asymmetrical and unique Marine Corps officer. Our debate on interrogation techniques is not a new one, folks. America has previously struggled to uphold the rule of law. maintain the high moral ground, but still obtain actionable intelligence in a way consistent with our values. Then, like now, we faced a fanatical foe that routinely violated human rights. And I would submit to you that the enemy nations we faced then were much larger and much more lethal than the implacable sub-state actors we're currently engaged with. But I want to take you back to a time before the Universal Declaration of Rights was even signed. This was before the Convention Against Terror. This is before Common Article 3 of the Geneva Conventions. The year was 1942. And America was in a very bad way. Pearl Harbor had been attacked in December of 1941 with a loss of over 2,400 American lives. American military experts could not guarantee that an invading Japanese force could be stopped at the West Coast. The war machine was a juggernaut. It had crushed countries that stood in its path. The Japanese Imperial Army had previously wreaked havoc on China, killing at least 40,000 and maybe up to 300,000 civilians with impunity, and created so much death and devastation that the conquest of the city of Nanking was called the Rape of Nanking. Brutal games existed of killing unarmed men, women, and children. They were the norm as the war machine rolled over China, the Malaysian Peninsula, the Philippines, and Singapore. I had the pleasure of spending 2 months in Singapore last year and learned that the surrender of Singapore by the British Armed Forces was the largest in Great Britain's history. Throughout Asia, mass decapitations of civilians were common, rape widespread. Even babies were not spared from cruel deaths, as a gruesome internet search will reveal. On the sea, the Imperial Navy was undefeated, whereas my former service, the U.S. Navy, held on for dear life. Remember, the decisive Battle of Midway would not take place for 6 months in June of 1942. The United States of America needed reliable, actionable intelligence, and it needed it fast. The problem was this: very few Americans spoke Japanese. Because you remember, Japanese Americans were placed in internment camps and only allowed to fight in the European theater. But into the fray stepped an unlikely 56-year-old American man with no prior military experience. His name was Sherwood Moran, and he was a Christian missionary to Japan. As Providence would have it, Moran happened to be in the United States on furlough on Pearl Harbor Day. Sherwood immediately offered his services to the United States military. But as I said, Sherwood was no ordinary middle-aged man. He was what they like to call in law school sui generis, a unique class of one. His skills were so rare it's possible no one in the entire Marine Corps had the depth of his skills in early 1942. You may ask, well, what was his special skill? Well, he'd been in Japan since 1918 and spoke Japanese fluently. More importantly, he knew Japanese culture. This Oberlin College graduate and former philosophy major would make a huge difference in our war effort. So if any of your kids are philosophy majors going to Oberlin, there's hope. He was also a pacifist. And he had a liberal disposition, in quotes, according to one of his biographers. But he was attracted to the Marine Corps. And I'm going to step out here. I'm going to say it. There's going to be pushback. But America's preeminent combat force, who are often given the most dangerous military assignments. There is no time for rebuttal, ladies and gentlemen. Into the maw of war, Sherwood, who is instantly made a captain in 2003, he stepped in and made history. He was not a rifleman. He was not a combat officer. He was not a warrior with weapons of steel and lead. His weapons were his mind, his language skills, and cultural literacy. His duties were rare indeed, but he did more for his country with his skill set than he could have as a rifleman. You may ask, what did Sherwood Moran do? He was a translator, an interrogator. He didn't like the term interrogator. He liked to be called an interviewer of Japanese POWs. And it turns out that Captain Moran was the most effective interrogator or interviewer of Japanese POWs that the United States had. And he became a legend within the very small and insular military interrogation community. In fact, some of his techniques are still being taught. So you may ask, how did this unlikely pacifist missionary Oberlin philosophy major become the preeminent interrogator of Japanese POWs? He wrote a classic memorandum, and here's what it was called. You can find this if you do a diligent search. It was called Suggestions for Japanese Interpreters Based on Work in the Field. Suggestion. Just the humility drips off that page, because now it would be called requirements or policy for. But then he called it suggestions, and he worked in the field. Actually, he worked along right behind the front lines along the island hopping campaign. So it wasn't just the field, folks. It was very near the front lines. His work is a gold mine. And the heart of his approach was this. You want to hit the next slide there? Treat the suspects humanely. Or as Sherwood put it, I am talking as a human being to a human being. So if you see this picture here, it's the only picture that I found doing multiple internet searches using Sherwood Moran as a search term. There he is. You can see his back. The POW here had been an aviator, shot down, survived, and a third person who is identified. But he's having a conversation with the POW. This was approximately a year after Pearl Harbor. This was in Guadalcanal, which, as you all know, was a terrible campaign for all parties concerned. It was in the tropical rainforest. There was malaria, yellow fever, constant rain. Just a horrific place to fight a battle. And here's Sherwood just sitting and having a conversation. The practice at the time that Sherwood Moran became the instant captain was this. POWs had to stand at attention in front of an American flag, flanked by 2 guards. Moran would have none of that. He would sit down and have a conversation. He'd offer them tea, coffee, and as they did in 1940s, he'd offer them a cigarette, probably an American cigarette. What did they sell back then? Lucky Strikes. Probably issued to the sailors and Marines of the era. And then Moran would talk about the POW's town and how friendly the Japanese people were. He even knew, and I don't know what the right term in English for this, but there's a perfect Spanish term. It's a dicho. Any Spanish speakers here? A dicho is like a folksy saying. Help me out here, ma'am.
It's like the local phrases and all sorts of like local slang. What is like in Costa Rica, they say pura vida.
Pura vida, right.
But
It's
in DC, we say, well, what do you do? And by that, it's an introduction.
right. It's a pithy, culturally deep phrase that disarms people because you have to know the culture in order to use it correctly. So here's one that he would use with POWs. He'd say this in Japanese. A frog in the well knows nothing of the great ocean. Let me repeat this because it's late in the afternoon and it's kind of warm in here. A frog in the well knows nothing of the great ocean. In other words, the frog, who's the fighter, the war fighter, can only see what's at the bottom of the well. The frog has no idea what the big picture is, what the battles are that are raging in the area. So, how did the Marine Corps leadership respond to this asymmetrical warfighter called Captain Sherwood Moran? Well, in a word, beautifully. Headquarters allowed Moran to revise the interrogation manual. And I'd submit to you that his common decency was his biggest weapon. Because the POWs would in fact talk to Moran. And I find this really fascinating. Those of you with a military background probably would like to comment on this. According to Moran, aviators talk the most, then soldiers, kind of in the middle, and then sailors talk the least. Which in my experience, I would have thought the sailors would be talking as much as the aviators. But his finding was they didn't talk as much. So I'll make no further comment in the spirit of inter-service cooperation and love. But Moran was able to obtain actionable intelligence without torture, without abusive interrogation, without degrading or humiliating techniques. And as we all know in this room, the world community responded to the horrific global human rights abuses and genocide by agreeing to the Universal Declaration of Human Rights on 10 September 1948. And in a move that doubtless would have made Moran happy, Article 5 states it clearly. Here's a quote: "No one shall be subjected to torture or to cruel, inhuman, or degrading punishment, treatment, or punishment." Language is broad, I'll grant you that as a lawyer. But it also includes conduct that doesn't rise to the level of torture, but could be cruel, inhuman, or degrading. And obviously the Declaration has many more rights embedded in it, but I will only address Article 5. Because that's the only article that I really have real-world experiencing in dealing with as an official, as a former military officer. And therein lies a rub, folks. Because somehow in the intervening decades, since Moran's groundbreaking work, the United States forgot about Moran's successes. And that grievous oversight was brought into sharp focus in the current war on terror. Dave, can I have the next slide, please? If there is an iconic image that graphically displays that Article 5 of the Universal Declaration of Human Rights was ignored in the immediate years after 9/11, it's this. Now, this is Abu Ghraib, as we all know. Some of you may have actually been there and maybe worked on the investigation. I worked with an Army JAG who did. He told me the worst pictures are not public, which blows my mind because the pictures I've seen are terrible. But you've got a guy standing on a crate. He's got wires attached to his fingers. I believe he may have wires attached to his genitals as well. You can't really tell from this photo. He's hooded, and we don't know how long he's up there. We don't know if there's any current there or not, but he probably thinks that there is. And this was not authorized by the U.S. Army. These were some rogue lower level soldiers thinking they were, I don't know what they were thinking. Getting actionable intelligence, I guess, would be their rationale for doing this. But sadly, this, in my mind, is one of the iconic pictures. But it's not a good picture for the United States. Because as we all know, human rights has been something that our leadership, our civilian leadership, have been talking since the 70s, since Jimmy Carter. He's the first president I recall ever talking about human rights and making it an important part of our foreign policy. So I ask you, ladies and gentlemen, is this torture? If it's not, is it cruel? Is it inhuman? Or is it degrading? I would submit to you, you could make very strong arguments that if it's not torture, it clearly is one of those other subcategories. Well, we had other legal prohibitions against torture or abusive treatment, such as 1949's Common Article 3 of Geneva. That mandated humane treatment for those out of battle or hors de combat, and prohibits, quote, outrages upon personal dignity, in particular humiliating and degrading treatment. And I just this to my national security class at Wheaton just a week or so ago. And you got to understand, enough time has passed. I mean, to us in this room, 9/11 was a week ago, right? I mean, it's still right there. I mean, we know where we were. We know who we were talking to. We know what we were doing the second we heard the news. But with my students, they were in grade school. They were 5, 6 years old. They don't have a clear memory of 9/11. So that's how much time has passed for our younger Americans. So they didn't really seem to know about this picture. And I showed them in my mind, even the worst pictures of the naked human pyramid, of the detainees there in Abu Ghraib that were forced with hoods on to form a naked pyramid, with the female soldier in the back smirking. I mean, it's a shameful picture. It's the antithesis of what we teach. We should be teaching our soldiers and sailors and airmen and Marines. And I noticed that my class, the young men and women couldn't stare at the picture very long because it was so uncomfortable. And I asked them this very simple question. I said, if you don't think this is torture, is this cruel, inhuman, or degrading? And to a person, they said yes. It's at least inhuman or degrading. You could say it was cruel as well. And what our administration at the time did concede was that Common Article 3 does in fact apply to non-state actors. Because there was initially an argument that Common Article 3 does not apply to sub-state actors. That because Al-Qaeda wasn't a state, didn't sign any accords, didn't sign any treaties, and it didn't apply. So we could take the gloves off. Well, they conceded that, in fact, that was not true. So Common Article 3 does apply to non-state actors who are out of battle and being detained in places like Guantanamo. And the final legal obstacle to trying to justify maltreatment of detainees was 1987's Convention Against Torture, which the United States ratified in 1994. And it provided this: no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. Allowing abusive treatment was no oversight, ladies and gentlemen. My former employer, the Justice Department, issued in 2002 the so-called torture memos, which narrowly defined torture and allowed for abusive, degrading, and humiliating treatment. In my mind, these memos were the ultimate stay-out-of-jail card. And you'll notice no one's ever been prosecuted. And no one will ever be prosecuted for that, because the Justice Department said it was okay to engage in this conduct. So no sane prosecutor is ever going to bring charges, because no jury is ever going to convict. I know I wouldn't have authorized a prosecution of somebody when he pulls out this memo saying that they could engage in this type of conduct. And I also note that the military judge advocates general were not consulted when the new policies were implemented, which facially authorized treatment that violated the Universal Declaration of Human Rights, Common Article 3, and the Convention Against Terror. And my former boss, Alberto Gonzales, when he was White House counsel, famously dismissed the Geneva Convention as inapplicable in the war against terror in this way. And I'm not going to give you just the quaint soundbite. I'll actually read you what he wrote, so you can be the judge of what did he intend when he made that quaint comment. By the way, Matt, it's great to have more than 10 seconds to present remarks. Like some of you have done a lot of media, and you've got 10 seconds. You've got to boil it down to 10 seconds. If you can't do that, pass the mic, because the machine wants 10 seconds. Enough of that. Here's what Gonzales wrote. In my judgment, this is a quote, in my judgment, this new paradigm renders obsolete Geneva's strict limitations on questioning of enemy prisoners and renders quaint some of its provisions, requiring that captured enemy be afforded such things as commissary privileges, script, athletic uniforms, and scientific instruments. That's the entire quote. In my judgment, This new paradigm renders obsolete Geneva's strict limitations on questioning of enemy prisoners and renders quaint some of the provisions, such as, which I just said. And the Justice Department's Office of Legal Counsel, which issues memoranda binding on the executive branch agencies in the government and subject only to overrule by federal courts, concluded in 2002 that essentially any treatment not leading to imminent death or organ failure was not torture. Let me repeat that. OLC issues an opinion. It's binding on the rest of the executive branch, subject to only to federal courts overturning it. It's a powerful position. Well, Jack Goldsmith leaves academia, becomes the new OLC, looks at the memos, withdraws them. Within a year, Jack is pressured to resign, so he resigns. After Goldsmith left, the memos were reasserted for a season. But in my mind, that was the beginning of the end of the U.S. foray into illegal human rights policy and conduct. It was the beginning of the end of the United States violating the letter and the spirit of international laws that mandate humane treatment. In the early days of Guantanamo, there were many interrogation techniques which did not violate the Justice Department's torture memos, but did in fact violate international law. Let me give you a very short list, because the list goes on and on. But these practices, which were allowed, included sexual assault, humiliation, sleep deprivation, sensory deprivation, mock executions, use of dogs, temperature extremes, and sensory bombardment. And then there were the so-called EITs, the enhanced interrogation techniques. And they included stress positions, forced nudity, exposure to cold weather, and waterboarding. Next slide, please. So, for sake of clarity, only a small number of the 800 or so detainees in Gitmo ever received EITs. Still, in my view, any number was too many. And in 2005, former Vietnam POW Senator John McCain sponsored the Detainee Treatment Act, which limited U.S. interrogation techniques to those authorized by the Army Field Manual. I think it's 32-54. None of the Army Field Manual techniques rise to the level of degrading, humiliating, or abusive treatment. Nothing comes close to torture. In fact, I had my students, my 18, 19-year-old students, read an Army Field Manual. And they actually got it. I mean, you know, we went through all the different techniques, the fear up, and the, you know, there's, I think, 19 or 20 different techniques. Students loved it, which probably the only time in Wheaton's history that an Army Field Manual was taught outside of a ROTC class. Some of the techniques were similar to what Captain Moran would have used, such as the direct approach, which was to sit down and have a conversation. And interestingly enough, the FBI uses rapport-based interrogation, which in my view is essentially the civilian form of the direct approach. And here's what the FBI Legal Handbook for Special Agents says, Section 7.2.1. It says, "It is the policy of the FBI that no attempt be made to obtain a statement by force, threats, or promises." According to the Army Field Manual, the direct approach is the most effective technique. So Moran was right. And according to testimony provided in 2008 by former Inspector General Glenn Fine of the Justice Department, here's what he said. Detainees did not expect to be treated as human beings. The FBI had successfully obtained information without the use of aggressive techniques. If aggressive techniques are used long enough, detainees will start saying things that they think the interrogator wants to hear just to get them to stop. The use of aggressive techniques failed to take into account an end game. Even a military tribunal would require some standard for admissibility of evidence. Now, I detect a little bit of DOJ bias there, looking down their long noses at the military commissions, but that's an aside. Obtaining information by way of aggressive techniques would not only jeopardize the government's ability to use the information, but it might also have a negative impact on the agent's ability to testify at future proceedings. And here's the money quote. Using these techniques was wrong and helped Al-Qaeda in spreading negative views of the United States. So this is from the DOJ Inspector General. Now, little personal story here. I actually know one of the FBI agents who was there at the early years of the War on Terror. He investigated the USS Cole bombing. He interviewed alleged terrorist Abu Zubaydah. But he used rapport-based interrogation. He was getting results. It wasn't until the CIA contractors, who had never interrogated anyone, not even a criminal suspect, started using abusive interrogation techniques, did this agent ask to be relieved of his duties. And FBI headquarters let him do that. So, just to put this into context, as United States Attorney, I authorized over 11,000 prosecutions over a 6-year period. I can't recall one time in which there was even an allegation of an abusive interrogation technique carried on by any of the 14 or so federal investigators that had the case. It never happened. So I can conclude from that that this type of conduct is rare domestically. Congress also made the standard clear in 2005 with the Detainee Treatment Act, which says no individual in the custody or physical control of the United States government, not just the military, but the government, regardless of nationality or physical location, shall be subject to cruel, inhuman, or degrading punishment or treatment. So, the Justice Department's torture memos would not be permanently rescinded until 2009, when a new administration came to power. I was mobilized back into active Navy service after 20 years in the reserves in the year 2008. The Detainee Treatment Act was in effect. I knew I'd be working Guantanamo war crimes cases. I had heard of all the negative publicity, I'd read them, but like any skeptic, like what you would do, is I called the office and I talked to a couple of people that I knew, and I said, I need the real scoop. I need the gouge. What's going on? Is this a fair system or is this an unfair system? And one of the guys I talked to was a defense attorney from Northern Virginia. He goes, no, this is a real system. We have a new law in place. It's fair. And I figured that if a criminal defense attorney would say that, I could probably take that to the bank. So I mobilized. And it's like they're saying about Washington. Never go to Washington thinking you'll be here for 2 years because you'll be here for 30. So I mobilized thinking it'd be a 2-year mobilization, and I spent 5.5 years on orders, which is probably some kind of Navy JAG record for being mobilized for that long. But the act was further refined in 2009, and in my view it has the hallmarks of a fair system. There's a presumption of innocence. The government has a burden of proof beyond a reasonable doubt. The accused has a right to counsel, the right to present evidence, to confront government witnesses. There is, I will say this, and this is where the office gets criticized a lot. There's a lot of criticism over the greater ability to use hearsay. But in my mind, since the cases were so much older and involved battlefield action and not just a mere crime scene, that allowance made sense to me. I know some of my defense friends disagree. It's a free country. But I also knew that as a former state and federal prosecutor, I could not use coerced statements because they're worthless. Can't use them in court. I knew that abusive interrogation techniques enormously complicated my job as a prosecutor. In some cases, they ruined my ability to charge a case. And I was able to observe some FBI interviews in Gitmo of suspected terrorists, and I saw something that Sherwood and Moran, I think, would have felt very comfortable doing. They sat down, they gave him some food, they had a conversation. Nothing shocking my conscience. Nothing I thought, well, maybe we shouldn't be doing that. In fact, with defense counsel present, I was allowed to meet an alleged al-Qaeda bomb maker and talk to him. We had lunch. I had lunch with a suspected terrorist with his lawyer. I just need to make that clear, with his lawyer present. And there was nothing unusual about the lunch besides the fact that the suspect's ankle was chained to a U-bolt in the floor. The guy was pretty charming, actually. He spoke a little bit of Spanish. I returned the favor with what little Arabic I knew. But in a word, it was a decent meeting. Which brings us to 2015. Our footprint is much smaller now in Southwest Asia. The Justice Department is continuing to convict defendants of terrorism in a small number of important cases. Military commissions are slowly moving forward with the immense 9/11 case and USS Cole cases, plus a couple of smaller cases. But I think I stand on solid footing by saying that the Universal Declaration of Human Rights is alive and well in America. In my view, it is. What is the way ahead in this era of humane treatment of terrorism suspects? I think the way ahead is a return to the past, a return to the high moral ground where America practices what it preaches. And I'm encouraged by the U.S.'s return to the historic observance of the rule of law. This long war will someday have an end. I hope we never have to sacrifice our core values on the altar of expediency. I trust we're able to abide by the letter and spirit of the Universal Declaration. And I'll end my remarks, mercifully, by quoting Sherwood Moran. Now, he warned other interviewers to not blindly copy what others do by citing a Japanese proverb that said that such a person was like a crow attempting to imitate the cormorant, catching fish and drowning in the attempt. Let me read that again. Don't do this. Don't be the crow attempting to imitate a cormorant, catching a fish and drowning in the attempt. In my view, the years after 9/11, the United States was like a crow that tried to imitate the cormorant using torture and abusive interrogation techniques. But unlike the crow, we did not drown. We choked, we survived, and we'll never make that mistake again. Next slide. Thank you kindly for staying awake.
Questions?
Stunned silence. Yes, ma'am.
I'm from the National Defense University. So just a quick question on what you said earlier. You said that now the government holds the burden of proof at beyond a reasonable doubt. Do you think that this is an attainable level that actually helps with these investigations, or do you think that that level of the burden of proof is, I don't know, difficult sometimes?
I think it's got to be that high standard, because for every other type of criminal prosecution, whether it's tribal, state, federal, it shouldn't be easy for the government to obtain a conviction, especially for a felony crime. So
if you answer from the podium, we can get you on tape.
Oh, okay.
He's acting like a trial lawyer and walking through the jury box.
Yeah, I do tend to walk around a little bit. So the question was, should we keep the burden of proof at beyond a reasonable doubt for the Commission's cases? And my answer was yes, we should, because it should not be easy for the government to convict an individual of a felony level crime. And in all our other courts, tribal, state, federal, we do require that very high standard. So yeah, it is harder when we've got the evidence that happened on a battlefield 12 time zones away in a foreign language 10 years ago, and the government has only classified information to use. I'll tell you this, the hardest cases I've ever done have been these commission cases. They are by order of magnitude more difficult than even a difficult federal prosecution. Because here in the US, we know where the witnesses are. It's a relatively new case typically. We have an agent who has testified in court. You've got the reports right there. It's not classified. I mean, of the 11,000 cases my office prosecuted, I think I had 1 or 2 classified cases. In an average day at the commissions, I reviewed more highly classified, compartmented type of evidence than I ever did as a U.S. attorney, and I had the same level of clearance. So, great question. Al?
How do you explain, I guess, the distinction between being a prisoner, akin to a prisoner of war, in which case you're able to be held until the end of hostilities, versus someone who's going to go before a commission or may not go before a commission, and the whole habeas corpus aspect of that? Is there a problem with holding these people indefinitely?
Why don't you explain habeas corpus for the non-lawyers?
So habeas corpus is an ancient Anglo-American, actually Anglo legal concept that prevents indefinite detention of prisoners. It was a limit on the Crown. So the Crown couldn't just grab an enemy and put him in a hidden jail somewhere for forever. So it forced the Crown to produce the person, the corpus, el cuerpo, right? Bring the body in front of the court. This is what you're being charged with. So it's a great check on imperial power. So Al's question was, how can we hold these guys, these detainees, indefinitely? Like we can in a bona fide war against a nation state, we can, under international law, keep them until the hostilities end. Now, with our parents' generation, or grandparents' generation, as the case may be, we knew when the war was over. There was a VJ day, there was a VE day, the war was over. There was a signing ceremony on the USS Missouri, the war was over. When's the war going to be over on this war on terror? I have no idea. Somebody knows, please tell me after class, and I'll write the book. So they do have essentially the same rights as POWs. Some future president is going to have to make the hard decision to cut them loose. Now, I don't know what that magic date is. I will say this: there is some precedent, because if you know some of the World War II era cases, the Nazi saboteurs that are referenced in help me out here. Not Eisentrager.
Nuremberg?
Not Nuremberg. There were 6 saboteurs that were picked up in Florida and in Long Island. Right. 4 were given the death penalty, executed. 2 were given life sentences. So the 2 were cut loose by President Eisenhower in the 50s. But he had a political reason for it. We were making friends with West Germany and needed a strong, supportive partner against East Germany. So Eisenhower made that political concession. Oh, this is going to drive me crazy. I just briefed that case. It's one of the big 3 World War II era commissions cases. Anyway, Quirin, the In re Quirin case. So I do think at some point we may have the law on our sides, but we're going to have to disregard that and let them loose. Now, I think we're down to 136 detainees in Gitmo. Of about a third have been pre-cleared for release, but we can't find a place. We can't find a place to take them. But think about it. We'll say you're the president of Spain, and if the United States doesn't want to take these Chinese Uyghurs, these Chinese Muslims who are a threat to China but not a threat to the U.S., why should Spain want to take them, right? So, and then there's about a third that potentially could have faced military commissions charges. And then there are about a third that they're probably guilty, but we can't prove the case in court because of age of the case, classification issues. That third category, in my view, as a former defense counsel and a former prosecutor, is the most troublesome, because how long do you keep somebody that we think committed a crime but we can't prove in court? Is that against our fundamental American values to indefinitely detain somebody? I think the answer is yes. I think the answer is some president soon, within our lifetime, within the next 10 years, will have to make the call. And then pray that that person doesn't reoffend when they get out. Yes, ma'am.
This is kind of a follow-up to that question. My name is Sharon, and I was on a presidential task force about getting on the National Academy of Science, and they're talking about an Egyptian detainee that was being fed ice cream and became obese, and now he has all these issues. And it was kind of strange because they were doing it to get information, but he really had no information, and this was still going on like 3 or 4 years ago. But he hadn't, I believe, been charged with a crime. I believe that he could not go back to his country like some of the detainees back at that time from Yemen. And they were not aware of what had happened to their families. Is it cruel? Most people think it's cruel to keep people away from their families for a decade and to not let them know what's going on. What is their communication like with their family
Sure.
members?
The International Red Cross does make scheduled visits to Guantanamo, and they do send letters back and forth. So there is some contact. Yeah. It's not as if they disappear into a dark hole and are never heard from again.
Thank you. Do you have any, do you know about that Egyptian detainee? I'm sure there was like...
Yeah, you know, and at one point, I actually knew his name.
Yeah, I can't remember.
And I'm not going to attribute it to age. It's learning academic issues, I guess. Yeah. You know, it's funny you say that because there's another guy who loved Twinkies. This is serious. I mean, you can't make this stuff up. But yeah, he ate so many Twinkies that he started to, really put the weight on. These detainees are entitled legally to medical treatment. So if the Navy doc can't fix the problem, they will fly in specialists from the mainland to treat these guys.
They were getting people to treat diabetes and it was interesting because it brings back more issues. So.
Well, and I kind of like what Colin Powell said 10 years ago. We broke it, we own it. So we broke this guy not through abusive interrogation, but by giving him a horrible diet. And we've got to help fix the problem. I think there is a moral responsibility there. Yes, sir.
Carl Gollin, a retired customs agent, spent most of my career in Miami. Once received the U.S. Attorney's Office Award from Dexter
Hey.
Bateman.
Yeah.
Law enforcement officer, you called it
Sure.
the Dexter. We called it
The Dexter.
Yeah. But a couple of points. The idea we broke it, we own it.
Mm-hmm.
In human history, it seems like since Cain slew Abel, that's the pattern of how government strengthens its role in all cases. It breaks things and then it assumes control and promises the population will fix it. And in our country's history, one of the main points, differentiating points between liberty and slavery, in a sense, dead slavery, has been the monetary system. And this is off topic in a sense, but thinking of when we may actually restore dignity and peace globally, we forget that we unilaterally abrogated our obligations under the Bretton Woods Agreement to maintain a stable international unit of exchange.
Mm-hmm.
And so much of the driving force between the sense of injustice globally is from our perpetually inflating our unit of credit, and we militarily tie it to the petrodollar that OPEC countries
Right.
will keep selling at oil in the dollar. So just for your book, I was going to suggest when we restore a Bretton Woods system that,
Mm-hmm.
that creates a fair playing field for all countries economically,
Mm-hmm.
it would curtail some of our ability to militarily expand, but might be healthy.
Thank you. I've been in the Southern District of Florida many times. Did a couple of conferences at JADF South or East. I know it's changed its name, but down in Key West. And I thought, what a great location to be a Coast Guard officer.
Or customs.
Or customs. Yeah.
Well, the truth can be stranger than fiction down there. Anything is possible.
I heard about this term wet feet, dry feet policy of interdicting immigrants. And if you make it...
Only Cubans.
Cubans. If you're a Cuban national who makes it onto the land, you're good. If you're interdicted to sea, you get repatriated, right? But if you're a Haitian or any other nationality, you're out of luck. So yeah, I mean, there is something about Miami that's Twilight Zone-ish, I guess, when it comes from a...
That's where I regret. I was with Customs as of the time we merged with parts of immigration.
Mm-hmm.
We were in Homeland Security, and Customs was always fairly distinct. I mean, it was things were fairly clear legally. We
Mm-hmm.
dealt with things crossing the border, anything except people. But of course, immigration with people, it's always politicized. And
Oh, yes.
Very different corporate or organizational culture between Customs and immigration.
Yeah.
What role, could you comment on the role that the internet played in bringing some of this to light? Just the role of the internet in this whole drama of calling the U.S. to account for some of what it did.
Oh, well, gosh, I mean, we have a very robust human rights community in Europe in particular. Amnesty International, I know, is based out of London. They're on top of it. So, the idea that the government can do a lot and do it secretly, it's really a fiction. I mean, there's a secret facility in Gitmo that nobody's supposed to know about, but you can go on Google and see an aerial picture of it. You can see a satellite photo of that. So, and in using domestic law enforcement, I think it's a lot more difficult now to conduct an operation as a government entity or a servant and not be documented in some way. I mean, look at the videos you see on CNN of these shootings. I mean, when I was defending police officers in the 90s, it never happened. I had to take the word of the field investigators that showed up and took pictures of the casings. Now there's a chance, if you're in a big city at least, that shooting is going to be captured on video. I think that's a good thing. You know, Rodney King was beat up, and how do we know that? Because we can see the video that the civilian took a photo of, or a video of that. So, you know, there's an interesting verse that what you want to keep in secret will be shouted from the rooftops. I don't know what the reference is, but I think for the government engaging in misconduct, I think that's really true. We try to keep things secret, but the power of the internet is just so massive and pervasive. I mean, I got a taste of that when I went to Vientiane, Laos, and the streets were dirt. You had to be careful where you walked on the sidewalks because the sewers were right underneath, and there were holes in the sidewalk. All that to say, there were internet cafes everywhere in Vientiane, Laos, and that was 2006. So governments can run, but they can't hide from the internet. That's my take. Yes, ma'am. Or
Just building off of that, then on the opposite end, as someone who works with the law for government and things, what sort of direction do you see the government going in for crimes and or terrorist attacks coming from this internet space, this cyberspace? And how do you, as an offender, really deal with that?
well, I mean, I think you're going to see more lone wolf type of attacks thwarted because of keying in the right search terms. So if you got some kid in Dubuque who is maybe inspired by ISIS, and maybe he realizes he can't actually go there and fight for ISIS, but maybe he wants to get his uncle's AK-47 and go to the local mall and start killing people. Because kids, and I've asked in my class this question, maybe some of you younger ones can answer this, my class couldn't. Why is there a need in this generation to document everything? It's a mystery to me. I mean, kids are documenting crimes, felony offenses, and they're putting it on Facebook, for crying out loud.
It's
David.
a vanity exercise.
Vanity.
It's hey, I'm cool, I did this. We had kids, or a group of girls at my undergrad who stole giant brass letters from our sign at the front of the university and put it on Facebook, and the police found them in 20 minutes.
Of course. It's government exhibit A, right?
Yeah, here's you being stupid.
So, I hope that answers your question. Sir.
So I just wanted to kind of ask how you found out about Sherwood Moran, because I've read books about Abu Ghraib and whatnot, and the interrogators moving forward, they reference Nazi interrogator who used report to gain
Right.
intelligence and World War II. And I was just curious.
You bet. I will give up my secret. I'm a compulsive magazine reader, and about 10 years ago, the Atlantic Monthly, hard copy, not the online version, but the hard copy, ran a story on Sherwood. And I thought, I've never heard of this guy. I know a lot of Marines. I've never heard of this guy. And because my parents were missionaries, the fact that it said he was a missionary, went, oh, wow, whoa, I'm going to read about this guy. And the fact that his treatise, his work was still being used by the interrogators, it just fascinated me that you had, this guy, the least likely person on the planet to become a Marine Corps or World War II era officer, had just the right skill set. And I think it's a really compelling story because history has validated what Moran stood for. And you can actually go do a search on him. There are a couple of good websites. His family maintains one, and you can read more about him. He was an amazing man. And all this, and I'm Navy, I'm not Marines. I love my Marine Corps brothers and sisters. But I will say this about Moran. You would think that as he's in his retirement home, he'd have a cross on his bed. Guess what he had up on the wall? Globe and Anchor. So it was a transformative experience for him too, obviously. Matt, how many more questions do I have? David?
You are at 5:30, so you've got half an hour.
Wow. Well, I'm not sure I want to punish you with half an hour more, but I'm happy to answer a couple more questions, folks. Sir.
A politically incorrect question. In the fall of 2001, as an agent with U.S. Customs Internal Affairs, I was one of many agents assigned to Fresh Kills landfill going through the rubble of World Trade Center number 7, the third tower that collapsed that day. And I just want to ask and encourage that in your national security class, you might encourage your students to consider all the evidence that might have been briefly in the news that has since been well suppressed, that points towards things being a little more complicated than the official story. For example, now there's still 28 pages of the congressional investigation of 9/11 that are still withheld.
I thought it was all public now.
No, HR 428, the congressional 9/11 investigation. President Bush, I think Obama has continued it, withheld 28 pages that pertain apparently to Saudi and/or Israeli perhaps foreknowledge.
Can we stay on topic, please? Yeah, I'm not trying to be disrespectful, but stay on the topic. Sure.
Okay.
Well, with regard to 9/11, the issue of false flag terrorism, would seem relevant in how all circumstances tend to unfold. We never, let's not speak of terrorism, but never the potential for false flag terrorism. Things that are blamed on.
Okay.
You don't have
Thank
to.
you.
You don't have to answer that. I mean, it's an observation. It's
Sure.
not a question. You don't have
I
to-
understand.
Yeah.
Thank you. I was not aware of that, sir.
I'm glad that we try to do things by I'm an Army War College fellow here. I'm a chaplain in the Army. I'm glad we take the high moral ground. There were some concerns in the news about when we gave out the terrorist enhanced interrogation report that the Senate released a while back, that our opposition could use that as propaganda against us. So they use all kinds of things for propaganda, but I just wondered if you had any ideas on that, or since you're studying this and teaching this, any mitigation ideas, or you think us taking the high moral ground will kind of counterbalance that anyway, and it's the right thing to do regardless?
Yeah, I don't think we should take a utilitarian view on that. We do the right thing because that's what we stand for. Because we're the good guys and they're not. We do the right things because it's the right thing, not because it wins us favors. So I in fact had my students read some excerpts of the majority report and the minority report, which came out, and I wasn't troubled at all, because if any of you are lawyers, which I'm sure you are in Washington D.C., it's not unusual for there to be a split opinion. I mean, our Supreme Court does that all the time. But what do I pay attention to? I pay attention to what the majority says. So the majority of the Senate said that torture didn't work, we shouldn't do it. It doesn't represent what we stand for. And I mean, I take a very simple view on it. That is, we're the good guys. Good guys aren't torture. Bad guys torture all the time. We expect that from the evil empires and the Nazis and from the human rights abusers. We don't stand for that. So we have to hold the line there. We cannot take a utilitarian view such as, well, it results in good things. Because I just don't buy that now.
Even if it did result in good things, there are also bad things that come from it that may be secondary, tertiary. And that you can get good things doesn't mean you can't also get good things through the non-abusive, non-coercive techniques that you were talking about. So just because you may, and that's disputed, but even if you can't, that doesn't justify doing it at all. There are other reasons. Perhaps you can speak to the impact for our troops in the field by this kind of stuff going on our side. What's the legitimacy of those kind of techniques being used against our folks? What's the likelihood that the other side may use them and justify it
They don't need any provocation. And getting back to the chaplain's comment, they don't need any reason to want to kill and torture us, because they hate us because of who we stand for. And one of the many things I learned at the commissions is they don't just hate Christians and Jews. They hate Muslims that don't buy their radical, wacky ideology. So they hate most of their own community, in addition to Jews and Crusaders. They like to call Christians Crusaders because of the history, you know. But that was a revelation to me. Wow, they also hate their own community. So I don't think they need any provocation to want to kill and torture and kill innocents. And I think a partial solution, and I'm glad to see that some of the Muslim nation states are stepping up, like Jordan and Egypt, and are putting their money where their mouth is. They're actually engaging in offensive military operations against ISIS. Because we can't be in the position where it's the Christian and Jewish nation of America going in yet again to the Middle East and creating, you know, pain and suffering. This is, I mean, read this month's Atlantic Monthly on ISIS. It's the clearest article I've ever read. It's extremely long, but it's right on target in terms of what I learned at the commissions. There is a scriptural basis for everything ISIS is doing. This is not a political movement. It's a religiously based movement. They base everything they do on their interpretation of Quran, which, by the way, is rejected by every legitimate imam in the world. But there has to be more ownership within the Islamic community of saying, these guys do not represent us. They're crazy, they're wackos, and we reject it, in my view. Any other? Yes, ma'am.
Last question. Do you think that Gibron will ever be closed? Because I know there was an argument before that once we got all the prisoners out, then we were actually closed Guantanamo. What is your thoughts on that?
It won't be closed anytime soon. I think it'll keep shrinking. We'll keep finding countries. I don't know if this is even true or not, but I imagine there's probably financial incentives to the country that's willing to take this detainee. And you look at a world map, you see places like Bermuda and Vanuatu and Portugal taking a handful of these detainees. But I don't see it close anytime soon, because you remember, as long as Congress is in opposition to what the administration wants to do, and as long as Congress has the power of the purse strings and doesn't want to pay for any transfer, the administration is blocked. Now, if we get a Congress who's willing to spend the money to transfer these folks, then different outcome. But I don't see that happening anytime soon. Yes, ma'am.
Somewhat of a follow-up to that, a few years ago they were talking about Guantanamo, what they could do because it was a strategic location, and they were actually talking about the Presidio model from San Francisco. Presidio was converted to a national park. And they were actually, it was bizarre, I felt like I'd been drinking because they said they wanted to make a strategic center for peace and kind of use that facility with some parts of some big negotiation. And I thought that was drinking, but now that I'm looking at the relations with Cuba, is there a scenario where you see something in place? But I think strategically for the military, we need that base.
We do. It's our eyes and ears to the Caribbean and in many respects Latin America.
Correct. And the image of the people that work there, they come back, and because so few people serve in the military these days, they feel like there's a stigma with saying that you worked at Guantanamo, which I think is something that needs to be altered. You know, if you did change some of the usages for that base, it might then, I guess, change the time.
Yeah, I mean, I think unfortunately, because here's a little bit of military historical trivia. It's our oldest overseas base. We've had it since 1902. We got it as an aftermath of the Spanish-American War, along with Puerto Rico and Guam and some other locations. And initially it was a refueling coaling station. That's where our fleet refueled. And then it became a refresher training base for our Atlantic fleet. And then it became a interagency drug interdiction important location, which it still does. It's got other uses, but you know, when Rumsfeld said it's the least worst place, I think that's probably a pretty good description of picking Guantanamo. It's a huge base. It's 45 square miles. There's plenty of room to add and take away. But somehow you're right. We've got to disassociate Guantanamo with human rights abuses. Because what's the first thing you think of when you think of Guantanamo? That iconic photo of the guys with the orange jumpsuits, right? They're on their knees. There's a chain link fence that's X-ray, Camp X-ray, which was closed 2 months after that picture was taken. Sorry, I get a little bit.
They need a rebranding.
So they've got to rebrand Guantanamo because right now, or for the past 14 years, 13 years, it's associated with the worst of what the United States is able to do. Any other last minute questions or comments? Thank you very much. I appreciate it.